Welcome back, ladies and gentlemen, to the Layman's Law School, where, in this case, two Southern gentlemen lawyers sit around and discuss some of the legal issues today and hopefully give you laymen out there some sort of insight to what's going on in the news in a way that you can understand. Today I have with me my esteemed co-host, Shawn Merschlack.
I'm always glad to be here, and it's interesting that, I've never sat in this chair before. Mm-hmm. Because Reid has been a diehard podcast official with us.
That's right.
And this is maybe the first time that he's ever missed.
Yeah, I think it is. It's the first time. We're without our color man today.
But unfortunately, we don't get to see Chace wince as he slugs down a Bud Light because, I looked in my refrigerator and I didn't have any Bud Light either to bring. He was...
like a good American.
Chace was very of the belief that maybe me and Reid had conspired and that I would somehow show up with Bud Light, but we're still going to start off with a drink.
That's right. We're starting off the year correct.
That's right. Happy New Year.
Happy New Year to you. So today we're going to cover one of the more contentious issues in the news. The exclusion of Donald Trump from a number of the state's presidential ballots.
The attempted exclusion.
That's right. The attempted exclusion at this point. It has not sort of been followed through on, and the issue has not been resolved. And we're going to talk a little bit about the process of how that would actually be decided and sort of what this exclusion is actually based on. Shawn, can you explain to the viewers what these states are using in order to try to justify taking him off the presidential ballot?
Sure. What they are using is the insurrection clause of the 14th Amendment. That is something that hadn't been used in a long, long time. Mm-hmm. I was thankfully had the mind when you asked me the trivia question earlier when the last time it was used.
Yep.
I didn't know the date, but I knew it was Abraham Lincoln. So
right. Well, he was the only one that's been removed from a ballot, and it resulted in
a
the Civil War. Right, and that the insurrection clause actually was put in the 14th Amendment. The 14th Amendment, of course, gave equal protections to all citizens and freed the slaves. But one of the things they wanted to do with this Section 3 was to exclude Confederates, people that had been part of the Confederacy, from holding office.
Sure.
So if you could just explain or read the text of that.
Sure. Essentially what the text of the insurrection clause of the 14th Amendment says is that no person can hold office in the United States who, having previously taken an oath as a government official or member of the military to support the Constitution, has since engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. So very, very broad, a lot of things to dissect there. But
yeah, one sentence, it looks like. A compound sentence, but
a run-on. Most of us would call it a run-on sentence. But as you can see, like you said, when this was put in place, it was essentially meant to. There was a civil war, and they did not want anybody who was part of the Confederacy, who was trying to defect from the United States, to be able to hold public office going forward.
Right, and this is it's important to note here that, and we talked about it all the time, that the way in which words matter and the way in which you interpret words matter. And for example, what does it mean to engage in insurrection? Do you have to throw a Molotov cocktail at the Capitol building? Do you have to attack a Capitol police officer, or can you give a speech on the mall explaining that you need to fight like hell? Where is that line drawn?
It's up to everybody's unique interpretation,
right.
And normally we look to the courts, for interpretation of what that is. But in this case, I don't think that we have a whole lot of court decisions that encompass or give us guidance on what that is.
Absolutely none. this is real. I think I'm going to say rarely been used. I don't think it's ever been used in this sort of fashion before. And when we talk about case law and what it's used for, it's used to help interpret the statutes, where the people that wrote it did not give a definition of what it means to engage in. Did not say whether or not the person had to be convicted of engaging in insurrection, right? The courts have to fill that gap in with the case law, and typically it's the Supreme Court that interprets a particular case that comes to them, and they decide what courts below them will use in order to decide a particular issue. And ultimately, I think that's what we're going to sort of have here. This is going to be an expedited appeal up to the Supreme Court. But I think the first one...
And that's good, because we need some. Normally when we look at cases, that don't involve, this, we look, for instance, we would look at a case that had the word engaged in it and what engaged means. And we would go and look and we would say, oh, well, the Georgia courts have said that engaged in means you aided, encouraged, abetted, all these different things that they have made it broader or given us guidance on what activities actually mean engaged in. And in this particular situation, we need that guidance.
Yeah, and there's something called the Black's Law Dictionary. We have to use it in law school. It's referenced a lot of times. But basically, it's a compilation of how the courts have interpreted any given word and what its actual definition is. And I have a couple of them here for insurrection. It's basically a rebellion or a rising of citizens or subjects to resist their own government. Insurrection consists of any combined resistance to a lawful authority of the state with the intent to cause the denial thereof, when the same is manifested or intended to be manifested by acts of violence. It is a federal crime to incite, assist, or engage in rebellion or insurrection against the United States. So that is a federal statute, and the Georgia Code basically mirrors that almost exactly. But the question is in this particular case, does somebody like Donald Trump have to actually be convicted of this particular crime in order to be disqualified? Well, this has never occurred.
I would certainly hope so. I would certainly hope that there would be some type of due process that he would be afforded before he is precluded from running for the president of the United States just based on the whim of a particular state. And obviously those states that are moving towards that or asking for that to be done are states that are not traditionally pro Donald Trump or pro Republican Party,
Right, and this is where it becomes really important to understand the rule of law and why that's so important, because it can we can develop a political atmosphere where one side dominates another, and they might not necessarily have the right. They might not have the answers to the legal question in front of them, the way to govern in front of them, and the the minority side needs to be able to sort of challenge that in some way and provide enough evidence or have some sort of hearing in order to have the truth actually come out. And I think that's the important part of sort of what doesn't need to be denied to Donald Trump here, and that is the due process. Due process basically. You take a whole sort of semester in law school to try and understand this, but it basically, before you can basically have something taken away from you, right, and you have to have some sort of adjudication, some sort of fair hearing that allows you to present evidence, to question your accuser, and it varies. How much due process you're given varies based on the right that's actually being taken away. I think this is a pretty significant one. And this brings me to the way in which he was taken off the Maine's actual ballot.
Sure.
Sheena Bellows is the Secretary of State, and a state statute actually is very unique to the state of Maine. Not many states have anything like this, but she is required to basically make a determination about the eligibility of a particular candidate to be put on the ballot. And usually this is determined by, are they a citizen of the United States?
Sure. Aren't the qualifications for the president that he has to be 35
Yeah,
years
30,
of age
36,
and
yeah.
a resident of the United
Yeah,
States?
U.S. citizen, yeah.
Or natural-born citizen of the United States?
Not a convicted. I don't know. Is it convicted felon? I think makes you ineligible. I'll have to look up.
It's very minimal what you need to meet the requirements of. I had to meet a lot more requirements just to get in law school.
Yeah. So she made a determination and basically a factual finding that he had actually engaged in an insurrection by, putting out what was claimed to be a false narrative about the stealing of the election, then basically encouraging his supporters to come to the Capitol and then to march on the Capitol, to fight like hell. You can read his language and the things he did before and after in multiple ways, but she interpreted that as meeting the threshold or the standard for engaging in an insurrection.
So this must have been a months and months and months long trial that they went through with hundreds and hundreds of witnesses from both the opposing party and from Donald Trump's side. Is that correct?
That is not correct. That is not what occurred here. So, like I said, this was really normally like a rubber stamp type, process, and the denial was not much more than that. In that she reviewed what the public record showed about what occurred and made a decision that he had engaged in an insurrection. And luckily, the Maine's court system allows for her decision to be directly appealable, and Bellows, to her credit, has suspended the effect of her decision and her order to have him removed until the superior courts in Maine have made a ruling. I anticipate that the superior courts in Maine are likely to kick this straight up to the Maine Supreme Court.
It's at least. It's a very good thing that she's made that decision, because in a lot of other places, I think that we wouldn't have that. Mm-hmm. We would have a government official that says that this is my duty under state statute. I've determined that that Donald Trump committed insurrection, and he's not eligible in this state, and he's not going to be on our ballot until another a court tells me that I have to put him on the ballot. And what she has done is said, this is controversial. This is my decision, but I'm going to stay that decision until courts give me some guidance or make a determination.
Yeah, and I think that in part kind of helps the whole thing along, because, as you know, with appeals and the process of moving things through the court, that her making a truncated kind of decision about what she thought actually speeds up the process by which we will actually get some sort of finale to this. And the election is coming up pretty rapidly, and so this actually does need to be decided as soon as possible by the Supreme Court. We can't have multiple states following different rules when it comes to electing a president, and that brings me to the next state that sort of most notably in December took him off the ballot, and that is the state of Colorado. Now, in that particular case, the Supreme Court did hear this, and it was a 4-3, I think, decision to take him off the ballot, finding by clear and convincing evidence that he had, engaged in an insurrection, and therefore removed him. But again, in that particular case, there was not any sort of discovery process. Mm-hmm. There was not.
So in Colorado, the Colorado Supreme Court has already approved it, and he will not be on the ballot in Colorado. Is that correct?
Well, here's the thing. Right now, that is the ruling.
Unless it goes to the United States Supreme Court.
Exactly. No, it's already on its way, going through that process. And what's interesting to read about that is some of the challenges that have been made in the appeal. And the most interesting, there's some about the Republican Party as an association has a free speech right to put whoever they want on the ballot.
Sure.
That's questionable.
Well, I mean, what was would Donald Trump win Colorado anyway?
Probably not.
Exactly. So I mean, it's more of the principle so that we can get some ruling on a decision for all of the states.
That's right.
Because there is some states that are more borderline, split down the middle, that could go either way. And if you've removed Donald Trump, well, then obviously that can have a major impact, swaying the election one way or another for that particular state.
Yeah, and I think that it's going to move through pretty quickly. But some of the other arguments were that he was not an official, and this is a lesson in statutory construction.
You have to be an official. That's correct.
Yeah.
And
well,
I'm pretty sure that the president would qualify as a government official.
Yeah.
But kind of what do we say when we get those defense pleadings back in when we file a lawsuit that they've used a shotgun approach?
Yeah,
that they have denied everything and raised every defense
possible
that has nothing to do with the case, just so that we have to turn around and say, explain to me point number 4. Explain to me point number 8 and give me more information on that. And then they withdraw all those things because it really doesn't make sense.
It's nonsensical. Yeah, the argument is based on a couple of clauses in the Constitution. And this, like I said, it's a lesson in statutory construction when you're trying to interpret a particular word in a statute. And you can read the statute as a whole. And, in this case, the Constitution, reading it as a whole, there are over 25 times in which the presidential office is referred to as an official or as an office holder. And what they're clinging to is a couple of situations in which the president is, given the power to appoint all government officials, judges, so on and so forth. And therefore, because he is the president, he cannot appoint himself. Therefore, he cannot be an official, because he's charged with appointing officials. Like I said, it's tenuous, but I think it will be knocked down because of that canon or that bullet point as far as the things you look to when you're trying to interpret a statute. You look to the entire document, and the entire document makes it clear that he's. But the way in which I think that he has his best, or the best argument I think he has, is the argument that the 14th Amendment is not self-executing. In other words, that in order to enforce this and have a private citizen the way it has occurred in this particular case, aside from Maine, right? And to bring an action to enforce a statute, you have to be deprived of some sort of federal right, and that right and that deprivation has to be specific to you.
And that it basically goes back to standing. That's probably the more commonly used, term for it when, if I don't like something that's going on in Atlanta, Georgia, I can't just file a lawsuit because I don't like it. There has to be some way that I have actual legal standing, some way that I've been actually legally affected, my rights have been infringed upon. I can't just say, well, I don't like that Atlanta doesn't allow you to do X, Y, Z.
Right.
It would be where, I was in Atlanta, I was doing X, Y, and Z, and I got arrested or fined or, somehow like that. Well, then, when I'm going to court, my rights have been, infringed upon type thing. That's when I would have standing for it, not just that, well, I don't like, that they don't do a certain thing in Atlanta.
Right, and the best example I can give of what I mean by this, about you being able to actually bring a lawsuit specifically, and you having to be given authority by statute to bring a type of lawsuit in order to enforce a right or a deprivation of a right, is it was a Brown v. Board of Education, where basically in the Equal Protection Clause. And so, like, for instance, if you're African American and you are basically denied the right to go into a particular college or a school based on your race, okay, you, under that amendment, can actually bring a lawsuit to enforce your rights when you're being discriminated against based on your race.
Correct.
You're right, and that is written that in statute that you can bring that type of claim. There is no equivalent claim for when you believe a president or a person has engaged in insurrection. You have a right to actually bring a lawsuit and enforce that. There is no clause like that, and I think that might actually be Trump's, sort of best argument, in part because typically the Supreme Court does not, rehash the factual findings of lower courts.
Sure.
Typically, they only look at the issues of law and how it was applied, how things were interpreted, and how the Constitution is interpreted. And so, if the Colorado Supreme Court decided by clear and convincing evidence that he engaged in insurrection, they're going to accept those findings of fact. But they are also going to consider all those other legal arguments, whether or not these people have standing to actually bring this. And I think that those are the things on which that this is going to actually be decided. But some case law needs to be decided in order for us to be able to sort of get a clear picture of what's going to happen.
Well, and it needs to be decided for everybody, regardless of the way that you sway in your political affiliations. What you have to think about is that in 10 years from now, in 15 years from now, let's say that the Republicans are in the White House and the Republicans hold the House and the Republicans hold the Senate, and the Republicans have all this power. And there's a great upcoming, leader in the Democrat Party who would be a great president. But the Republicans use this power to remove this person from ballots in different states based on because they don't like him, and they can find something that they claim is insurrection because he says, "Oh, we need to change the government." Oh, well, we say that that's insurrection,
right?
So it's there's some long-standing issues that need to be resolved with some law and some guidance from the courts. Otherwise, as contentious and as divisive as our political system is currently, and really America is, unfortunately, we're going to have this problem over and over and over again until we get some guidance and some rules.
Yeah, and I think it just did some guidance on what kind of was required to remove somebody from in particular, a presidential ballot. I mean, there's governorships are very important. Presidential ballots, I think, are incredibly important. But for a state official to be able to make a quick cursory decision that this person engaged in insurrection and therefore is off the ballot is not something that is going to or will pass muster when it comes to removing somebody from the ballot.
I agree, especially when they were supposed to be basically saying, is this person of age? Is this person natural citizen? Did they pay the qualifying fee? I mean, those are the the standard things that they were seeking out a way that was obviously prompted by people in Maine's opposing party to try and remove him from the ballot.
Yeah, the way I've heard this characterized is some people are talking about the philosophy, the sort of philosophical or moral issue that has to be decided here, and this is a columnist, Charlie Savage. He wrote that the Supreme Court's decision pits one fundamental value against the other, giving voters in a democracy the right to pick their leaders versus ensuring no one is above the law. Do you agree with that sort of characterization? That sort of encompasses what this issue is about?
Say it one more time.
Sure, yeah. This sort of decision, the decision, and in particular, he was talking about the Colorado Supreme Court's decision, was that the case actually pits one fundamental value against another, giving voters in a democracy the right to pick their leaders. Because as we talked about, how important that is. Last time it happened, we had somebody removed, we had a civil war, versus ensuring that no one is above the law. Because currently he is on trial, I do believe, for the incitement of it.
Well, I mean, he's on trial for a number of things. I mean, he's on trial in New York for tax evasion. He's on scheduled to go on trial in Georgia, the district attorney in Atlanta, Fulton County, is pressing for this thing to start on trial in March. And, it's just upsetting to me how politically motivated it all is. To me, I would say, Madam District Attorney in Fulton County, let's look and see how many people that you have sitting in the Fulton County jail, pending trial, unable to post bond or without bond, that have been sitting there 2 and 3 years waiting for their trial. But, we've got something that involves Donald Trump. We've got to move. It's got to be at March. It's got to be right in the middle of an election season. It's just so politically motivated. All of these things that it's unfortunate that our country has come to this, regardless of what side it is, whether it would be Republicans trying to do something like this to Democrats or Democrats trying to do this to Republicans. The number one thing, I think there needs to be, due process to all sides involved before all these decisions are made.
Sure.
And to remove somebody from a presidential ballot without that causes irreparable harm should it later turn out that he did nothing. Right. He wasn't inciting a riot. He did not meet the qualifications for anything close to insurrection. Sure. Once that election is held and he wasn't on that ballot, well, he lost the opportunity to even if he wouldn't have won Colorado. Things like that. It's a sad state of our political climate.
Well, I have faith in our judicial system, and I think that they will apply the same balance of scruple and judgment that they always have. Because what I find typically is that when these Supreme Court justices get into that position, that they are actually a little bit humbled and guided by the position that they're actually in and making some of these decisions. And they all have different ways of interpreting the Constitution, and that's fine. That's what the sort of whole system is about, competing ideas, the best ones winning out. But I have faith that this thing will be decided, and that we will have a new system for determining this type of issue going forward, because I think it's absolutely vital in order to have people actually believe in their institutions.
Sure.
Not only the judicial system, but in this particular case, the electoral system, that somebody gets a fair shake. And you have to prove sort of your case in court before this type of
and I agree that the United States Supreme Court is the best place for the decision to be made, just because, like you said, they take their job very, 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 very seriously. Occasionally, there are opinions where you say, well, I know why that opinion kind of went that way, but when you're talking about essentially fundamental rights and important positions like the President of the United States, they are going to do everything they can to effectuate the rule of law.
Rule of law and the democratic sort of principles, in which kind of Republican principles in which the country was founded. I agree, but do you have a prediction as to what's going to occur in the time frame, whether or not it's going to occur before November?
I believe it's going to occur in November or before November. I think it's got to occur faster than that. Yeah. Because these primaries are coming up. I think South Carolina's primary is in March. I don't know when Colorado's is and everything. So we have these primary elections where you already have to be on the ballot. But what impact it will have on these states that are doing this, that Donald Trump isn't going to win anyways, I don't know what it's going to have on the general election.
I was talking more along the lines of like whether the Supreme Court will hear it. I think it'll come out in June. They mostly come out with these decisions in June.
Sure.
A lot of the big cases get or big opinions get put down in June. And like I said, you are correct. Colorado, part of the issue with getting the Colorado decision to the Supreme Court is the fact that most of those people vote by mail, and they start sending out mail-in ballots in February. And so, not having him on there, right, and that's the only ballot they got. They're not going to get issued multiple ballots.
Sure.
they can always write it in, but I'm not sure if that'll even be counted in this particular case. But anyway, I do believe that this will be heard, that ultimately it will be decided on the issue of standing, that there's no individual right to kind of enforce that insurrection clause. And I'm not sure they're going to touch upon what it means to actually define what it means to engage in, and whether or not you have to be convicted. Usually when they can kick the can down the road, they do.
They make a decision, then they say, there's no reason for us to even dwell on this other stuff.
Exactly. But ultimately, the union will prevail, and we will move on, whether it's with Donald Trump or another American president. Thank y'all so much for joining us today. I hope you learned something, and we'll see you next time.